That's interesting. Okay, so we're all set, Aaron? Okay, good morning and welcome. I am Senator Sharon Carson from Senate District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. 6, let's start the meeting by taking roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during this meeting, which is required under the right to know law. I will call the roll. Senator French.
Harold French, Senator District 7, broadcasting live today from the studios in Concord, New Hampshire, out of the office of Sullivan Law Firm. Chip is in the office, but not in the room.
Thank you. Senator Khan. Yep, we can't hear you.
That's okay.
Good.
Good morning, Senator Khan.
Let me be a little more clear. Senator Khan is present in Keene and home. My wife is elsewhere in the house. Good morning, all.
Thank you. Senator Gannon.
Senator Gannon in sunny Sandown, the heart of New Hampshire wine country. And I just want to, no one else is in the room. And I want to congratulate my Camel alumni as I was at graduation last week. And hopefully he's soon working or at Babson doing his master's in business. Thank you.
Congratulations for your son graduating, Bill. That's awesome.
Yeah, grad school now I got to pay for. Good.
You.
Senator Whitley.
Yeah, you have to pay for grad school, Senator Gannon. That's a good deal. Good morning, Senator Becky Whitley. I'm in my home in Hopkinton, and I'm alone in the room and alone in the house.
Thank you. And I am Senator Sharon Carson. I am at my home in Londonderry, and my daughter is in the room with me, and my husband is somewhere around in the house. Okay, I need a motion to enter into executive session.
So moved.
Senator Gannon moves, seconded by Senator Khan. Is there any discussion? Okay, seeing none, I will call the roll. Senator French?
Yes.
Senator Khan?
Yes.
Senator Gannon?
Yes.
Senator Whitley?
Yes.
And Senator Carson? Yes. Before we get started, I'm going to make this announcement for the public that might be listening in. We're going to take up a number of bills this afternoon. So if you're the bill that you are interested in, their number gets called, please tune in or come back at 1:30, and that's when we are going to be taking up these bills. The first one is House Bill 108. Next will be House Bill 195. Then House Bill 236. No, excuse me, no, 236 we're going to do. House Bill 307, House Bill 542, House Bill 566, and House Bill 625. So let me repeat those again. House Bill 108, House Bill 195, House Bill 307, House Bill 542, House Bill 566, and House Bill 625. Those will be done this afternoon, beginning at 1:30. We're going to take these bills up numerically, and we are going to start with House Bill 125. This is the bill relative to post-arrest photo distribution by law enforcement. Is there a motion on this bill?
I move on to pass, and I can speak to that.
I'll
Okay,
second.
we have a motion about to pass by Senator Whitley and seconded by Senator Khan. Okay, Senator Whitley, please.
Thank you, Madam Chair. So I think, in looking at this bill, I think, we've all taken a really close look at this bill and thought about this important balance between public safety and privacy, something that is, as legislators, we really need to carefully attend to. And I think that this bill does a good job of balancing the interests of public safety and privacy well. It provides exceptions for when the release of a photo is necessary for public safety. The bill doesn't seek to conceal basic arrest information, such as an arrestee's name and the charge, just the photos that stay on the internet forever and that can be easily shared. So again, it's this good balance. I think it's important. This bill is important because people are innocent until proven guilty, but the public release of post-arrest pictures can really become a barrier for folks to getting housing, employment, personal relationships, regardless of whether that person ends up being convicted of that crime. And of course, we know that not all arrests lead to charges. Sometimes those charges are dropped, and many people, even charged with crimes, are acquitted. So again, there are very real interests here to balance between public safety, but I think this bill does a good job of doing that, and that's why I'm supportive of it.
Thank you. Are there any other comments? Senator Khan?
Thank you, Madam Chair. I think that this bill, and with the amendment that the House sent over, that it carves the necessary guardrails to the privacy provisions that it's trying to enforce. And I wrestled with this one, and I think that was evident in the testimony and the questions that we exchanged with those that provided testimony. We may need to come back and even consider some of the testimony that we had in subsequent legislation, and I'm willing to do that. But this bill, while protecting the privacy of people who are post-arrest and still awaiting adjudication, that's an important right to preserve, but it's also important that this bill preserves the right for law enforcement to pursue their investigations. It defines very clearly that law enforcement can release post-arrest photos if there is an imminent danger to the public. They can release it to other law enforcement agencies. They can release it to the public if there's that imminent danger. They can, if a person fails to show and appear at a court hearing, they waive the right to the privacy of that post-arrest photo. And they can, law enforcement can disseminate post-arrest photos to witnesses and other law enforcement agencies. So my point here is, I think that this through the House hearings and considerations was well crafted. And I think that they have provided to us a bill that I can support, recognizing there are going to be concerns either way that we go on this, and we need to be prepared to act if there are, in the future, if there's a necessity to do so. I support the bill as presented.
Thank you, Senator Khan. Are there any further comments? Okay, I have to disagree with my colleagues because in my opinion, this is about police transparency. The public has the right to know who the police are arresting. And it also, in my opinion, allows the public to see the condition of the individual when they were arrested. We all know that police officers are charged with abusing people within their custody, and the public can see if someone who's been arrested has been hurt, or they have a black eye, they've got cuts and scratches, and the public is then able to ask the questions. How did this person get hurt during the arrest? So for me, it's about transparency. The public has the right to know who the police are arresting, and it really sets up a kind of an odd system where the police cannot send out these photos, but any random person that's hanging around a police station can take a photo of that person and put that out there on Facebook. Look who the police have arrested today. What about videotaping people as they're being arrested? That is an image of that person. All that person's doing is being arrested. You don't know why they're being arrested, but that is going to be out there in the public. So the random person or a newspaper person can stand outside a police station and someone's coming in, they're doing the perp walk, and take their photo and publish their photo there. So how is that person's privacy being protected when a random member of the public can just take their photo while they're going through the police and walking into the police station, or they're being arrested? As a citizen, I believe I should have the right to know who the police are arresting. And that's what those photos do. They let us know. Do I think that there's times when those photos shouldn't be published? Yes, I do. And I agree with Senator Khan that that is probably something that we can work on and work with law enforcement to come up with different standards and criteria for releasing those photos. But oftentimes those photos are released because they want the public to see this person. Have you seen this person? They have been accused of burglary. Your property was burglarized. Was this person in your neighborhood? Kind of a thing. So I also see it as a helpful tool for law enforcement to help them resolve crimes. I understand the need for privacy, and I know that there many times people are arrested and their pictures are published and they're found not guilty. And maybe there's a way that we can address that issue to remove those photos from the public. And I know on the internet, once it's out there for good. But maybe there's something that can happen that can address that, but that bill doesn't. That, I think, is something that we can continue to work on. But at this point in time, I can't support this bill. I see it as transparency. I see it as informing the public. And to me, it kind of, if you hide these photos or you don't release them to the public, it's kind of like the secret police kind of a thing where people are just being arrested and no one's going to know. I just think it's important that the people have the right to see who the people are arresting and under what circumstances they're being arrested. So that's my say. Senator French?
I get a question of you, or of Rick. Is it mandated anywhere in statute that arrests are made public?
Are you asking me? I'm sorry.
Yeah.
Yes.
I don't know that there is a statute that requires it, but I think that a statute that creates a blanket exemption to certain types of government records may run afoul of Part 1, Article 8 of the Constitution, which requires accountability of magistrates and open government.
Mhm. Senator Whitley?
Yeah, so I just wanted to address that issue because, the bill is just seeking to, think thoughtfully about when these photos are released. It doesn't do anything, it doesn't say anything about concealing basic arrest information, like the name, the charge, that still is very much permissible. And certainly there's an interest for the public to know who has been arrested. I agree with you, Senator Carson, on that issue. But this bill doesn't address that at all. It still allows for that release of who is arrested and why. And the other
Mhm.
piece is, your point about, what if this is a burglary, it's important for the public to know. And I agree about that. And so I think that's why, the bill lays out the certain exemptions or exceptions for when the release of the photo is necessary. And so I think the bill does allow for that situation that you're concerned with.
Thank you, Senator Whitley, and I'm going to respond to your comment. I think the police already use discretion on releasing the photos, and I look at our three, really the large cities that we have. I look at Nashville, I look at Manchester, and the dozens of people who get arrested every single day. You don't see their photos in the paper. You don't see the photos of every single person who's been arrested. You just don't. And I think the police already use discretion. And I just think recently that there have been a few photos in the paper, and these people were accused of serious crimes. One of an individual who had raped a woman in one of the cemeteries in Manchester. And once the photos were released, people were like, yeah, I remember this guy. He had come through before and he has some issues. So it spurred a conversation. But I think the police are already doing that. We don't see the photos of every single person who's being arrested. It's only the really serious crimes where it's major drug trafficking or some other child abuse or child sexual abuse or something. Those photos are the ones that we're seeing. We're not seeing all the other people who get arrested. The people who haven't paid their parking tickets or, a small nonviolent crime. We just don't see those people. It's only the serious crimes where we see people, their faces. So I already think that they're doing that. Maybe there needs to be legislation that very clearly outlines under what circumstances they can release the photo to the public. But I just can't see passing this bill. To me, it is about transparency, that the people have the right to know who the police are arresting, and quite frankly, the condition in which they've been arrested. If I see someone's picture and they're pretty beat up, I'm going to ask questions. Were they in an automobile accident? And was this the result of a chase? Or was it, hey, they slipped and fell and banged their face or something? I mean, it allows people to ask questions. And I think that by doing this, you're not going to allow that kind of conversation to happen. So I can't support House Bill 125. Are there any further questions or any further comments?
I guess
Senator Khan?
Yeah, I'm sorry, Madam Chair. There's noise in the background. Is that disturbing to anyone?
No,
Okay.
Can't hear it.
Yeah, I think the point that was made is that we're releasing photos, or the possibility of photos of people. I mean, we're not jurists. The public. I mean, that's the whole point of innocence until proven guilty, and the right to be heard in a court of law is to not enter those proceedings in prejudice because of a photo that's been released at somebody's, worst moment in their life. Who knows what hour of the day, who knows how upset that person is. And suddenly my judgment is cast because of the photo, the single photo that's been rolling around the internet with people commenting on it and saying anybody who looks like that must have committed, some kind of act that they're culpable for. So I mean, that's the bad side to this. If I don't know if what we're hearing is that maybe if we can't pass this in the form that it is, that we all have interest in wanting to find what kind of situations would justify a public right to know, and what kind of situations tip to the side of privacy. And maybe it's worth that extra effort. But the bill as it's presented is acceptable to me. But I'd be willing to continue to work towards some kind of passage on this bill.
Okay, thank you. Senator, in response to your comments, I've seen people who have looked at a picture of an individual and made comments. I mean, all you have to do is look at Facebook. But I would argue that usually the picture is accompanied by an article which talks about why the person was arrested. And that's where I think that people can become prejudicial and make judgments. I don't really think, I mean, they might make a snarky comment about how that person looks, but once they read the article and they see what crime the person's been charged with, that's when people form opinions about the individual. And maybe if you folks feel that there's a subsequent motion to refer this bill back to the committee and work on it. I mean, we have a motion of ought to pass in front of us right now. So I think we need to act on the ought to pass, and if that fails, then we'll have a subsequent motion. Okay, is everyone ready to vote? Okay, Senator French?
Yes.
Okay, Senator Khan?
Yes, with a
Okay,
chainsaw in the background.
Senator Gannon?
No.
Okay, Senator Whitley?
Yes.
And Senator Carson, no. So this this ought to pass. And Senator French, would you take this out?
Sure. Thank you.
Okay. Okay, next we have House Bill 139. Is there a motion on House Bill 139?
Motion to ITL.
Okay, there's a motion to ITL. Is
I'll
there a
second
second?
that.
Seconded by Senator French. Is there any discussion on this? I think that, well, I'll just say that I think that there were some issues with this bill that basically that the 90 days is problematic, especially with the docket, and it can cause problems and create confusion. And we had testimony from Mr. Head, who works with the courts, and he said that the Rules Committee at the court can take care of this. So I don't believe that there's a reason to pass this if this is something the court can take care of on its own. Senator Whitley?
Yeah, I would say too, this really kind of dismantles our existing court rules related to discovery. And so I think that requires a whole lot more work, particularly some concerns raised about the balance of power in domestic violence situations.
Yeah.
I would say ITL. Thank you.
Yeah, I agree with you completely. Is there any further discussion on the ITO motion on House Bill 139? Okay, seeing none, I will call the roll. Senator French? Senator French,
Yes.
okay, Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes.
I move
Okay,
consent.
okay,
Yes.
Senator French moves consent. Is there a second?
Second.
Seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, I'll call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Senator Whitley, would you like to write the blurb on this one?
Yes. Sounds good.
Okay. Okey-doke. Next, we have House Bill 142. Is there a motion on House Bill 142?
Motion for ITL.
Okay, Senator Gannon moves ITL. Is there a second?
I'll second that.
Seconded by Senator Khan. He beat you to it, Senator French.
I didn't hear him.
This one, we really didn't, other than the prime sponsor, there wasn't a lot of support for this bill. We heard from Honey Hastings and from with testimony, and basically what we heard is the Blaisdell case has taken care of this. So this bill is not needed.
I could have thought of a lot more causes also, so I didn't
I'm
want to add
sure you
them in.
could, Senator French. I'm sure you could. Okay, it just, the idea is that the Blanchflower case from 2003 has been overruled by the Blaisdell case. There's a new definition, and so again, we don't really need this. So, okay, is there any further discussion? I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley. Is there a second?
Second.
Seconded by Senator Khan. Is there any discussion on the consent calendar motion? Okay.
Yes, I would just like to mention that Senator Whitley was really fast on raising her hand on that.
It'll go in the
You got
permanent
it.
record, Harold.
Senator French, you got to be on your toes today.
Apparently.
Okay, so we have a motion for the consent calendar. It's been seconded. Are there any further discussion? Okay, seeing none. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Senator French, would you like to do this one?
I would love to.
Okay,
Jen?
great, thank you. Okay, next we have House Bill 161. Is there a motion on this bill?
Motion to ITL.
Okay, Senator Gannon moves ITL. Is there a second?
Second.
Seconded by Senator Whitley. This is relative to calculations of child support. I think this has significant problems. We heard testimony that this was a backward step and that the formula for child support is extremely complicated. And there's just a lot of problems with this. So I don't believe this is ready to move forward at this time. Is there any discussion? Senator Whitley?
Yeah, I agree with that, Senator Carson. I think there are a lot of folks that, provided some testimony that we do need to look at this calculation, and that may be true, but I don't think this is the appropriate vehicle. And, first and foremost, we should be considering what's in the best interest of the child in this situation. And I think this dramatic change in how we calculate really does not put the child first. And so for that reason, there's no way that I could support this.
Thank you. Are there any further questions? Senator Gannon?
Just really, yeah, you both have been right on point. What parents pay should be separate from time allocation. It's that simple. Thank you.
Right, I agree. Is there any further discussion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
Okay, moved by Senator Khan. Is there a second? Senator Whitley. Okay, is there any further discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Okay, Senator Whitley, would you like to take this one out?
Sure.
Okay. Okay, next, we're coming up to House Bill 179. This is relative to enhanced penalties based on prior convictions for driving under the influences of drugs and or liquor. We also have an amendment, which is Amendment 1582S. And can I get a motion on the bill?
Ought to pass.
Okay, so we have a motion of ought to pass. Is there a second?
I'll
On
second.
that ought
second
to
it.
pass. Okay, so we have the prevailing motion of ought to pass. So let's take up the amendment. And Rick, do you want to walk us through this amendment?
Sure. The amendment, the heart of the amendment is the change that was suggested by Senator French. It increases the penalties for a DWI subsequent when the defendant has a prior serious DWI and the change is that it amends the definition of serious bodily injury, and it only applies the aggravating factor if the accident causes injury to another person. Under the existing law, somebody can be charged with a serious bodily injury, DWI, if they're in an accident and cause serious injury to themselves. And the amendment would limit that aggravating factor to instances in which they cause a serious bodily injury to another person. And it increases the penalties from the existing 3.5 to 7 to 10 to 15. I'm sorry, to 10 to 20 for a negligent homicide.
Okay,
I'm sorry, you're gonna have to give me a minute. I haven't looked at this one for a week now.
okay,
But that's the gist of the amendment as opposed to the bill, is that it separates out the definition of serious bodily injury to another as the conduct that subjects a person to the increased penalty.
okay.
Can I
Okay,
ask for help from my colleagues? So I'm wrestling with this, and Senator Whitley and Senator Khan, if you can help me. I lean towards passing both the amendment and the bill. My problem is I do feel like I might be letting someone out just because they got lucky and hit a tree as opposed to a family. They really did the same act that could have killed someone. So I feel I might be putting someone back out in the street much earlier who has put other people in danger and just got lucky that they didn't hit someone. Does anyone else wrestle with that, or is that just me?
Well, Senator, if you were in a park firing a gun and hit the tree versus a person, you'd be charged with reckless conduct, not murder.
Okay. I see your point, Senator. Thank you.
yeah, and that's the difference. We
Okay.
wanted to, and based on the testimony that we had, the person that killed is or responsible for Tyler Shaw's death was someone who had been convicted previously of DWIs and charged and was punished for that. But we felt in talking about this and listening to the testimony that it's really about someone who gets into a car, they're drunk, and they kill another person because that's the circumstances that happen. They're responsible for the death of another person. should you be responsible? How are you going to punish someone if, yeah, okay, you hit a tree and you've seriously injured yourself? Okay, that's your responsibility. You did that to yourself. This is about somebody who's doing this to an innocent person, to someone else who just happened to be out on the road driving their car, or they happen to be out on a sidewalk or standing in front of a building or something, and somebody who's drunk comes along, hits them, or causes another accident, and that person gets killed. And so looking at a stiffer penalty for that, I think, is really appropriate, and I think it's in line with what the testimony that we had, especially from Mrs. Shaw.
Yeah.
Senator Khan?
Thank you, Madam Chair. And I think this legislation is saying repeated offense of negligent homicide has enhanced sentencing. And if it happens a third time, my gosh, even more enhanced sentencing. And I think hopefully we're becoming more responsive in our both our judicial and criminal justice system to helping people get past these kinds of situations where they recognize the risk of their behavior. But failing that, I think this is responsive to serious felonies. And
Senator Khan, I would agree with you, and we have some great public campaigns out there to educate people about the dangers of drinking and driving. And you have the designating drivers and people things that they will do to avoid situations like this. But sometimes this happens, and you find out that the individual that has killed another person, that they've been in trouble for drinking before. And at some point, I believe society needs to say enough is enough, that this person is a danger.
And just recently, Senator, we passed sleep it off in your vehicle, allowing them the opportunity to sleep it off and not take that chance.
Yeah. So we keep responding to this, but I think that there are just some people that just, for whatever reason, they just don't get it, that this is not a good thing to do. And unfortunately, people die. And in this case, Tyler Shaw died, a young man with a lot of promise and potential for a future. And it's devastated his family. And this was the third drunk driving conviction for the person who was driving the car. At how many, maybe the question is, how many chances do you give someone before they do something really, really bad? And in this case, a person was killed. So we are discussing Amendment 1582S. Is there any further discussion on the amendment? Okay, seeing none, I will call the roll.
So Senator, sorry, we don't have a motion on the amendment yet. We only have-
I thought we did. I'm sorry. Is there a motion on the amendment?
Motion
Okay,
for-
moved by Senator Gannon, seconded by Senator Khan. Okay, I'm sorry. I thought we already had one. Okay, is there any further discussion on the amendment? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
yes,
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Okay, is there we already have the motion of, excuse me. Can I get a motion on the bill as amended?
so moved.
Moved by Senator Khan, seconded by Senator Gannon. Is there any discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes,
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Do you folks want to talk about this one on the floor, or do you want it on consent?
I think we should put it on consent as we have plenty to discuss Thursday.
I would agree.
Okay, so is there a motion for the consent calendar?
So moved.
Moved by Senator Gannon. Is there a second?
I'll second.
Seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator French,
Yes,
Senator Khan,
Yes,
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Senator Whitley, would you like to be responsible for this?
Sure.
Okay. Okay, we're doing good here this morning. I don't know, I don't want to jinx us. Next, we have House Bill 180. We also have an amendment on this bill. So is there a motion on House Bill 180,
Motion for
the
ought to-
underlying motion?
Yes, motion for ought to pass.
Okay, ought to pass by Senator Gannon. Is there a second?
second,
Okay, seconded by Senator French. Okay, we have amendment number 1583S that I'm presenting to the committee. I think the underlying bill was, as introduced, was good. And I think that the way that it was amended was problematic. And I think that's a lot of the testimony that we had dealt with the second section, the B section that the House put in. And so I worked with Rick to come up with something that I think hopefully everyone can agree upon, that basically says that a person is guilty of a Class A felony if the person pays, agrees to pay, or offers to pay to engage in sexual contact as defined in RSA 632A:1, or sexual penetration as defined in RSA 632A:1(5) with a person under the age of 16 as opposed to the under the age of 18. And the payment or offer or agreement to pay may be made to the person who is under the age of 16 or a third party. We decided to keep it as a Class A felony, which again is in the original bill. And I think what was kind of difficult was they defined it with a person who is age 13 years of age or older and under 16, and the actor is 20. We all know the age of consent is 8. Well, not the age of consent, but the age of majority is 18. And it's entirely possible that you could have someone who's 18 and in getting involved in something like this. And I believe the term was the Romeo and Juliet clause. And I think that that is something that caused a lot of problems. So I think that we, by removing that section, keeping the Class A felony and doing it to the age of 16, anyone who is under the age of 16, because 16, I believe, is the age of consent. And I think that's what this amendment does. Okay, is discussion, folks, before we move forward. Senator Whitley?
Yeah, and so I would say, thank you for your work on this amendment, just based on the testimony that the amendment that came over from the House was really problematic, the particular carve out. So I appreciate that. And I appreciate that the amendment, particularly for crimes against children, increases the penalties. And so I appreciate that. And so my question is sort of this, and it sounds like you addressed this, but confirmation that Senator Carson, your changes in the amendment from the original bill as introduced were was it to make it consistent with existing law?
Yes. Correct, Rick? I want to make
Yeah,
sure.
I would add that it's sort of it combines two features. The original bill wanted to make all trafficking a Class A felony. That's what the original bill did. Then there was the amendment that came in. Paragraph B, Senator Carson's amendment, basically combines two things. It's trafficking plus an act that would be statutory rape anyway. So it's really takes those two things, says there's two aggravating factors here, should be treated as a Class A felony as a result. And now you have that in the amendment.
Thank you for that.
Senator Khan?
Yeah, and I think it's important I don't see where a Romeo and Juliet clause comes into effect when there is a payment for sex. And that's what this statute, what this bill is attempting to address. And I think it does so with clarity, and I appreciate the amendment and the work put into this. Thank you.
Thank you, Senator Khan, is that the penalty is harsher for doing this with a child, someone who's under the age of 16. And I'm hoping that everyone can support this. I think we can all agree that this just should not be happening. So, okay, so we have amendment 1583S. Is there a motion on the amendment?
To pass.
Moved by Senator Gannon. Is there a second?
Good.
Seconded by Senator Khan. Okay, is there any further discussion on the amendment? Okay, saying none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson. Yes. Okay, is there a motion on the bill as amended?
Move on to pass as amended.
Okay,
Second.
Senator French moves on to pass as amended, seconded by Senator Khan. Is there any further discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson. Yes. Is there a motion for the consent calendar?
So moved.
Moved by Senator Gannon. Is there a second?
Second.
Seconded by Senator Khan. Is there any discussion on the bill as amended? Excuse me, on the consent calendar. Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson. Yes. Senator French, not French, Senator Khan, would you like to take this one out?
Yes.
Okay, I thought you did.
And may I ask for 1 minute of, I gotta excuse myself for 1 minute.
Sure, that's fine. The committee will be in recess for 1 minute.
2 minutes. See you.
Okay. We've done 1, 2, 3, 4, 5, 6. This is pretty good, Jenny. We've done 6.
We're moving along, Senator, and
Yeah,
got
we're-
one on
we're
consent.
moving
That's great.
We're moving along. Okay, I've got to make sure that I have that amendment to 195. I thought I printed it.
I can resend it to you if you want, Senator.
Hold on, because I had, this was one that I did not have. I don't know why. Let me, yeah, could you send it, Jenny, to me?
Of course.
And I'll
I
print
think
it
I
off.
had it and I hadn't forwarded it to Jenny. That's why that happened.
Okay. Is this the one that we said we weren't gonna do till this afternoon? I think we said we weren't doing this one till this afternoon.
That's correct. Yeah, we're not
Yes.
doing that.
Okay,
Nobody's had a
so
chance to look
we're
at it yet.
skipping over that one. You know, the thing is I need my color-coded pens.
It's certainly a challenge without the pens and the paper and everybody in the room. so-
Yeah, I know. I'd rather, yeah, I think that, most of these we can agree on. I think we're gonna have the arguments this afternoon, so I'm hoping that this is helpful for Jenny. Okay, so this one is this
will be.
afternoon. Yep, we gotta try to make life easy. So the ones we're doing this afternoon is 108, 195, 307, 542, 566, and 625. Just want to make sure, because I didn't circle those. And now I'm starting to check things off. So,
Right.
okay, so we're going to 196.
We're checking them off one at a time, so they're getting through 'em.
Yep, we're gonna get it. We're gonna get it through. Okay. So 1, 2, 3, 4, 8, 9, 10, 11, 12, 15, 16. So I have 16 bills left. Am I correct, Jenny? Maybe I'm wrong. 1,
I have 17.
2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. You're right. I didn't count the one sitting in front of me.
Oh.
Okay, we'll get there. Okay, so I think Senator Whitley, so,
Thank you, Senator Khan. That was timely.
yes. Well, it's time.
I agree.
Sometimes we just need to take a few minutes to get that cookie
Quickly
in, or the brownie, or something chocolate to help you through.
How'd you know? How'd you know?
Senator Whitley, we worked together for 6 months now. Okay, I'm going to take the committee out of recess. We have postponed House Bill 195 until this afternoon. So next we're going to move on to House Bill 196.
Motion to re-refer?
Okay, Senator Gannon makes the motion to re-refer. Is there a second?
I'll second that.
Okay, so we have a motion to re-refer. I think that we had a lot of testimony on this, and I think this issue really needs to be clarified. And so that's why I think that we should hold on to this bill and try to work with this bill to see if we can get some sort of clarification. I know in my notes, I got questions about property. What is an other threat? When you talk about property damage, how are you defining property damage? I just think that there needs to be some more work done on this bill before we can consider it at this point. So I would support the motion to re-refer. Is there any further discussion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes,
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
Moved by Senator Gannon, seconded by Senator French. Is there any discussion on the consent calendar? Seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
yes,
Senator Whitley,
Yes.
and Senator Carson. Yes. Senator Gannon, would you like to be
Sure.
responsible for this one?
Yep.
Okay. Next, we have, let's see, House Bill 232. Okay, this is relative to non-public sessions under the right to know law. Is there a motion?
Motion to re-refer.
Is there a second?
Second.
Okay, so we've had a motion to re-refer this bill. Is there any discussion on this? I will start by saying we had quite a few right to know law bills this year alone. And I think that we need to take a look, especially at this one, because we're talking about releasing information on the proceeding with the acquisition, sale, or lease of real or personal property. We had testimony from the New Hampshire Municipal Association that says that this creates a hole in the real estate provision of our laws. And I think we need to just be very careful about what we're doing. And so I would like to hold on to this bill so we can work through it.
Yeah, I agree, Senator. I'd like to get the language right before we pass it and put it into law.
Okay. Okay, is there any further comments or discussion? Okay, seeing none. Oh, Senator Whitley, I'm sorry.
Well, I was just going to say, I agree. You know, we have seen a lot of right to know bills, and, you know, we have a new decision from the Supreme Court case, and it's just being, you know, those decisions are starting to roll out. So I think we'll have a better sense next session about how the court is interpreting this, what's working, what's not. And so I think holding it is a good idea.
Okay. Is there any further discussion? Okay, seeing none, I will call the roll. Senator Khan.
Ooh, tricky.
Yeah, Senator Khan.
Yes.
Okay, Senator French,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley. Is there a second? Seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator Khan,
Yes.
Senator French,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Senator French, would you like to do this one?
Yep, my team and I'll be happy to.
Okay, great.
You get a team? Nobody told me about that.
Senator,
Okay.
I'm the same.
Okay, next, we're going to House Bill 236. And we have an amendment. We have amendment 1662S. Is there a motion that we can start with?
Move on to pass.
Okay, so we have ought to pass. Is there a second?
Second.
Okay, so seconded by Senator Khan. Okay, this amendment was brought in by Senator Whitley. Would you like to just kind of walk us through this?
Yep. So it's just a simple addition. We heard some testimony from the Attorney General's office about the impact on litigation that they will bring. And so at their request, we just added one sentence at the end saying nothing in this section shall be construed as limiting any action brought by the state. And so this was that discussion about the term civil versus personnel. So it sort of makes that clarification.
Okay, thank you. Are there any comments or questions for Senator Whitley on amendment number 1662S? Okay.
Thanks for bringing it forward.
Yep. And thank you. So are there any further questions? I see none. So there is a motion of ought to pass. I will call the roll. Senator French.
Sorry, Senator, we don't have a motion on the amendment.
Oh, I thought we did.
Sorry.
I'll move to pass
Okay.
on.
I thought we did. Sorry. Okay. Is there a second? Okay. Thank you, Senator Gannon. So we have an ought to pass motion. Are there any further comments? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. So is there a motion on the bill as amended?
Move on to pass as amended.
If Senator French moves on to pass as amended, seconded by Senator Khan. Is there any further discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Okay, is there a motion for the consent calendar?
Move consent.
Moved by Senator Khan, seconded by Senator Gannon. Is there any further discussion on the consent, on the consent motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Senator Whitley, would you like to do this one as well?
Sure.
Okay. Next, we have House Bill 233. And I am going to make the motion to re-refer this back to the committee. Is there a second? Okay, seconded by Senator Gannon. This is a very complicated bill. And quite frankly, with all the work that we had to do over the past month, we did not have the opportunity to really delve into the language of this bill. We really need to get this right. And so I believe by re-referring this will give us the opportunity to work with all the interested parties in this bill, from doctors to everyone who expressed an interest here. So we just need time. We need time to work through the issues with this bill. So I'm asking to re-refer this back to the committee so we can do that work. Is there any questions? Senator Whitley?
Yeah, I would just say, this 233 is one of the most difficult hearings that I think
Yeah.
I've ever had to sit through, particularly as a mother. And I think this bill is a particularly cruel bill, and I think it deserves to be ITL'd. I think this was brought forward to fix a problem that just does not exist in New Hampshire. It pushes this incredibly dangerous and false narrative about reproductive health care and about our medical community. It suggests that our medical community is leaving infants to die, and that's just not true. And it's incredibly dangerous to even bring forth that narrative. I think this bill is about, legislators thinking that they know what's best for doctors and they know what's best for families, particularly families in the unthinkable situation of having a child who may not survive more than a few hours or a day. So I think this bill, because it is so dangerous, because it is so cruel, it is something that I think should be ITL'd instead.
Okay. Thank you for your comments. Are there any any further comments? Senator Khan?
Thank you, Madam Chair. I agree with Senator Whitley. I can understand that a re-refer motion it could maybe get us past the floor debate on this, but I just I guess my only additional contribution here is to say that if this re-refer passes, I hope that anything that comes forward on this has another hearing, public hearing, so that because the public testimony on this was pretty moving, and
Yes.
I personally would prefer to relieve people from the stress and emotion of needing to go through that again. But if we need to, I hope we do it with their ability to testify on whatever comes forward.
Okay, thank you. Are there any comments, any further comments? Okay, seeing none, I will call the roll on the re-refer motion. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
No,
Senator Whitley,
No.
and Senator Carson, yes. So it's 3-2, and I will take this one out. Okay. Next, we have House Bill 293. I'll cross this one out. This is relative to the procedures for adoption of a minor child. Is there a motion?
Motion to re-refer.
Okay, we have a re-refer motion. Is there a second?
Second.
Seconded by Senator French. Okay, I think that the issue here revolves around parents surrendering children and the issue of home study. I think this bill has a lot of merit to it. And I just think there's some things that need to be cleaned up within the bill. So I'd like the opportunity to work with our I can't even talk this morning. It's just a lot of stuff going on. To work with our child advocacy groups and work with folks that are dealing with adoption, and to see if we can get we can clean this up and we can get the support that we need to get something like this passed. So that's why I've asked for the re-refer. Senator Whitley?
Thank you, Senator Carson. And I would support that re-refer and offer to also help in getting this bill just right, making sure that we're again balancing those best interests for the child and leading
Yep.
with. I'm happy to work together on that.
Okay, thank you. Are there any further? Senator Gannon?
Yeah, I thought with no visitation, it made me nervous. I felt the representative who came forth and testified had a lot of reasons why, in some interests for the child to know where he's going to be and feel safe in a family setting and know where he is great. But I saw no visitation as an opportunity that we could have a terrible mistake. So I think the re-refer is in order at the moment.
Okay. All right, are there any further comments on the re-refer motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
yes,
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
And moved by Senator Whitley. Is there a second? Senator Gannon seconds. Is there any further discussion on the consent motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
yes,
Senator Whitley,
Yes.
and Senator Carson, yes. Senator Gannon, would you like to do this one?
Sure.
Okay. We are going to be doing House Bill 307 this afternoon. So next we are going to go to House Bill 334. And this is relative to prohibitions on carrying a loaded firearm on an OHRV or snowmobile. Is there a motion?
Move
To
to
pass.
pass.
Okay, Senator French moves on to pass, seconded by Senator Gannon. Is there any discussion on the bill? Senator Whitley?
Yeah, so, again, I have a young child. I live in a rural part of the state. And, I just think the risk of accidental discharge, even if it is slight, I think could impact anyone around that's in danger. I think there's a real concern of this sort of, we are normalizing the presence of guns every single place that we are. And, again, we're a rural state, and I think there is a place for that. But I think that for the protection of all the folks who are recreating around the folks, and particularly children who are participating in this activity, I don't think I could support this bill.
Okay, thank you. Are there any further questions or comments? Senator Gannon?
Yeah, we heard testimony from various gun experts, and I was also in Senator Whitley's camp at the beginning because I was worried about accidental discharge. I talked to many Second Amendment gun people. I went to gun shops, and they assured me and showed me that the safety mechanisms are, nothing's 100% foolproof, but almost as close to being, and that my fears of like the thing flipping over, gun falling out and discharging wouldn't happen. So while nothing in life is 1,000%, they did alleviate my fears. And so I am for ought to pass.
Okay, are there any further comments or questions? I'd like to point out that the testimony that we had, that this was a housekeeping bill. OHRVs and snowmobiles were inadvertently not included when constitutional carry was passed in 2017. And it extends the constitutional carry to off-road vehicles and snowmobiles. So, okay, I think we're pretty well, we know where we are on this one. We have an ought to pass motion. Are there any further comments on this bill? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
No.
okay, and Senator Carson, yes. So it is 4-1. And Senator French, why don't you take this one?
Thank you.
You're welcome. I know you like these bills. Okay, next we have House Bill 440. Is there a motion on House Bill 440?
Motion to re-refer.
Senator Gannon moves re-refer. Is there a second?
I'll second that.
Okay, seconded by Senator French. We had quite a few of these bills concerning the suspension of civil liberties that came to us. We just, again, this is one of these bills that we just did not have the time to work on this. So I've asked and support the motion of re-refer so we can have the opportunity to work on this bill. Is there any discussion? Senator Khan?
Yeah, it definitely would need reworking.
Mhm.
I think we need to step back and review, give ourselves some time to consider what powers ought to exist during a state of emergency. We've just gone through something that, and I think we're still there, right? And we're about to watch it expire, but history doesn't get made the day after you close a chapter on an incident, and other lawmaking bodies would step back and say, let's reflect on this, let's consider our actions, let's look at the actions that took place elsewhere, and be more thoughtful. I don't think that this is being done in as thoughtful a manner as it should be by the legislature. I think that the bill as presented is inexpedient to legislate. That will reflect my vote.
Okay, thank you. Are there Senator French?
Thank you, Madam Chair. We're just coming out of the state of emergency. I think it would be prudent to look at what was done, how it worked, what was necessary, and possibly what was not necessary. So a re-referral of this would give us the opportunity in the summer to look at it and make it a good bill. So I'll be voting for the re-referral.
Senator Whitley?
Yeah, I would agree with my colleague, Senator Khan, that, I think the more appropriate vote on this particular bill would be ITL because, I think the bill is premature, as I think we all agree, but it's also incredibly reactionary to our current situation. You know, we all heard a lot of every decision that was made by the governor, by local municipalities was questioned, even if it was backed by science. Wearing of masks was questioned, and I think the broad definition of civil liberties in this bill is really problematic. I agree that we need to take a look at the issue, the larger issue. I certainly don't think that this is the bill to do that. That's why I wouldn't support the re-refer, because I think we should ITL it.
Okay, thank you. I agree with my colleagues that we really need to take a look at this. In fact, one of the earlier conversations I had with the governor was we have to do at some point some sort of after action report. We have to look at the things we did right, the things we did wrong, and what we need to do in the future, and in a way create a blueprint as to how to handle these types of situations should they ever happen again. I see this bill as the first step. It's an important discussion because we're talking about the suspension of civil liberties during a state of emergency. And so I would like the opportunity to see if we can reach a consensus, if we can start that process of looking at what we did right and what we did wrong. So I'm going to support the re-refer motion. Is there any further discussion on the re-refer motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
No,
Senator Whitley,
No.
and Senator Carson, yes. And Jenny, I will take this one to the floor. Okay, next we have House Bill 474. Is there a motion?
Motion to ITL.
Okay, we have a motion to ITL House Bill 474. Is there a second?
second.
Seconded by Senator Khan. Any comments?
No expectation of privacy in public ways.
Yeah, okay. Anything else? Is there any?
I think
Senator
we also,
Khan?
I think we also heard that there were unintended consequences from municipalities that occur just because of the way the technology has evolved and how it's used by municipalities to control traffic signals, to control lighting, to control safety. And right now, I think safety is top of my list.
Thank you. Are there any further comments? Senator Whitley?
Yeah, I would just say, I think this bill needs some work. We could consider a re-referral, but if there's not a will of the committee, then I can support the ITL.
Are there any further comments? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes,
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar? Senator Gannon moves consent. Is there a second? Seconded by Senator Khan. Is there any further discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Senator Gannon, would you like to do this one?
Sure.
Okay. Okay, next we have House Bill 494. Is this, do we have a motion on House Bill 494?
Motion to ITL.
It's moved ITL by Senator Gannon. Is there a second?
A second.
Okay, seconded by Senator Whitley. I think that there were just some issues with this bill. In fact, we had testimony. This is identical to the next bill we're going to hear. Richard Head had claimed that this does not create facts for appeal. And New Hampshire legal assistance had some issues with this bill. I think that it's fairly broad, and I just, the specific orders, domestic violence had issues with this bill as well. I just don't think this bill is ready to move forward at this particular time. Is there any further comments or questions? Senator Whitley?
Yeah, I would agree, Senator Carson, with your assessment. And I think, you know, this bill would also really limit the judge's discretion in choosing the appropriate way to apply the law. And so that, in addition to the significant concerns raised for victims of domestic violence, I think ITL is the proper motion.
Okay. Is there any further discussion? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator French. I know,
Yes.
I had to mix it up a little, Senator French, to get your attention. Senator Whitley,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator Gannon,
Yes.
Senator French,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Is there anyone who would like to take this one out?
Sure.
Okay, Senator French, you're chosen.
I'm an expert on this.
I know, that's what I was thinking.
Oh,
I'm
no
sure you'll have
problem.
a colorful comment to include. Okay, next we have House Bill 495. Again, this is very similar to House Bill 494. Most of the testimony we had really does not, it just, there were other issues, just like there were issues with 494. So
Motion
is there a
to,
motion? Did I ask for a motion? Okay, Senator Gannon moves ITL, Senator French moves seconds. Right, Senator French?
Yeah, of course.
Okay. So again, this bill has, because they're pretty identical to the previous bill, same sort of problems. And this bill is just not ready to move forward at this time. So is there any further discussion? Senator Gannon?
yeah, we talked about it would just make it much harder for a woman or anyone to get a restraining order. And the court already can't issue unconstitutional orders, so I don't really think the bill makes sense anyways.
Okay.
But that's enough. Moving on.
Okay. Are there any further comments, questions? Okay, seeing none, we have a motion of ITL. I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
Yes.
Okay, Senator Gannon moves consent. Is there a second?
Yeah.
Senator Khan moves to second. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. And since we know Senator French is going to have so much fun writing the 494, I think you should write this one as well.
Perfect placement too in the
Yeah,
calendar.
it works
Thank
well,
you,
Senator
Senator.
French. Worked well. Okay, next we have House Bill 539. Yeah, relative to records of communication, common carriers. Is there a motion on this bill?
Motion to ITL.
Okay, is there a second?
Oh, did I?
Second.
Okay, so Senator Gannon moves, seconded by Senator French. Is there any discussion on this bill? Senator Whitley?
Yeah, I would say that that's the proper motion, and I could support that. We just didn't get a lot of testimony in this bill. It would be, a significant change, and I think, we need a lot more input that we just didn't get.
Correct, and I had a question about whether local police needed to get permission from the Attorney General to get records, and I questioned RSA 541A. I think there is existing law concerning this. We heard testimony that the police were just accessing this information, and I remember I put in a bill, I think it was back in 2009, that was based upon a case that happened out in Kansas. A young lady disappeared, and her parents knew that she always had her phone with her, and they wanted the communication carrier to allow them to ping her phone so they could locate her. It took 3 days for them to get the permission, and by the time they found her, she was dead. She had been raped and murdered. So I think that and the bill, what I did allowed police to get the records only if an Amber Alert had been declared. And we've also have the Silver Alert and those other things that are in place. So I think what this bill would do could possibly contradict those provisions that we already have in law as to when a police or law enforcement can access these records. And there are a lot of privacy things that are in place to protect people and their cell phones. So I'm okay with ITLing this. I think this bill needs some more work, and it needs a lot of clarification, quite frankly. So I can support the ITL motion. Are there any further comments? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
and Senator Carson, yes. Is there a motion for the consent calendar?
So moved.
Moved by Senator Gannon. Is there a second?
Second.
Seconded by Senator Khan. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
and Senator Carson, yes. Is there anyone who would like to take this one out? Senator Gannon. Okay, folks, we have completed the bills that we said we were going to complete this morning. This afternoon, we will take up House Bill 108, House Bill 195, House Bill 307, House Bill 542, House Bill 566, and House Bill 625. I am going to put the committee into recess until what, Jenny?
Sorry, I'm just going to be sending consent calendar blurbs during break. They're holding the calendar for us, so if you could please
Yes.
keep an eye on your emails. Thank you.
Okay, so I'm going to put the committee into recess. We will come back at 1:30, and everybody enjoy your lunch and updating all your records, and make sure you check your email for Jenny. Okay, take care. We'll see you.
never mind. So what's happening? Ava's joining us. Yay.
Good afternoon, Senator.
No, Jenny, I can't hear you.
Jenny, I'm sorry, you're muted.
Hey, well, the chairwoman is back with us, so
Was kicked out apparently for a minute there.
Hey, Bill, are you having trouble getting in? Yeah, I did too. Try again, okay?
so what's happening?
Okay. Okay, thanks. Bye-bye. There's something going on. I don't know what it is. Senator Ganning couldn't get in, but I guess he's being sent another link.
Yep.
So he should be able to get on. And is Senator French here?
I just spoke to him on the phone a couple of minutes ago, and he said he was going to be a few minutes late.
Oh,
Okay. Hey, Senator Khan.
hi.
I know I kind of panicked there for a minute. I'm like, we can't get through. And Senator Whitley had texted me and I wasn't able to because I'm trying to get through to everything. So, okay. Oh God, what's this stuff? Rick is here, good, because I'm just like, oh my goodness. Okay. All right. We're just going to wait a few minutes for Senator French, and then we will come out of recess.
Okay.
Jen, I didn't see any blurbs yet.
Yep.
Did I miss some or?
No, you didn't have any on consent, Senator.
Okay. All right.
So-
Okay. How is that
You've
working
gotten out
out?
of that one so far.
Yeah. Have people responded and gotten back to you and?
Senator Gannon and Senator Khan have responded to me.
Okay.
I'm sorry, I have not responded yet.
Senator Whitley is a bad student. Senator French says, French says that he
I'm
We're
read
not
them.
here, Senator Whitley, to berate
Senator-
you. Not at all.
You're just going to be cleaning off the chalkboards. That's all there is to it.
And I know Senator French had an emergency meeting at his business, so I suspect that's why he's a few minutes late.
Here's Senator French, and let me give Senator Gannon a call, make sure he's all set.
Okay, well, we have to wait here, so it's okay. It's a beautiful afternoon and it's not hot, which is great. Hey, Bill. You made it through.
We made it through.
You made it through. And this will probably, hopefully, knock on wood, be our very last Zoom meeting.
Yay.
Yep, because I imagine for the committees of conference, we'll meet in person. I hope, at least I hope we will be. And, by the time the Judiciary Committee gets back together in June, well, probably more towards the end of the year, we should be meeting in person. Just to let the public know that we're waiting on 2 members. And once they appear, we'll get started.
Jay, you look like you chopped down the cherry tree. You got the big guilty look. My kids have it sometimes.
Well, we're down to 1 now, so I'm not going off screen. I'll be good.
Awesome.
I know.
I already
We're
got my silver star from
That's okay.
Jenny
I-
for getting my blurb in. I think she
All
gave one
right.
to you too, Senator Gannon.
I think she gave me 4.
Yes, the-
I gave no one anything. This is all Senator.
And I did what Senator Whitley did. I had some chocolate chip cookies over here, and I ate some chocolate chip cookies.
Really? This is,
Yeah.
Something
Oh,
more
oh,
important.
you're
those
eating
are
a
too healthy.
granola bar.
I'm getting ready. I mean, it's, I was thinking 2:00, maybe I can hold out, but
Yeah, I made sure to plug in my iPad so it doesn't die, and
oh, that's a good idea. No,
yeah, because you don't want to be in the middle of this and all of a sudden start getting notifications that your device is going to die.
Yeah,
I'm hoping that it's not going to take us too long to get through the rest of these. We don't have that many. So I just want to thank you all for this morning and for all the bills that we went through this morning. Really appreciate everyone being prepared and ready. That helps so much. So thank you again.
yeah, you couldn't give us another week off, so I guess we had no choice.
Well, I tried. My goal was to be done by next week, but we were told they wanted them on the calendar this week, so we had to really move into gear, and we did that with all of your help, and so we're good.
And we worked out 108.
Yes, we have all the amendments to 108, and we'll take it from there.
Senator Whitley, are your chocolate chip cookies homemade?
I'll eat both homemade and store-bought. I do not discriminate.
That's
Senator
another
Carson
thing we
is
have in
famous, same.
common. Yeah, that's another thing we have in common, Senator Whitley.
Although
Don't care.
I have a really good recipe that requires the dough to sit for like almost 2 days, and then you
Oh,
put
geez.
a little salt at the end.
Oh, wow. Now you're going to have to pass me that because I like that. Senator French.
Good evening,
to see
Senator
you.
French.
What have I missed?
We did all
Everything.
six.
We've elected you to a number of positions and given you a number of bills you're going to work on and everything else. You know how that works.
I do.
Okay.
Sorry to delay you all.
That's okay. Things happen. We know that you run a business as well as perform legislative duties. So we're good to go. So that being said, everyone is present. We're going to go ahead and the committee is going to come out of recess. Just to remind the public that we are in an executive session. We have, I believe, 6 bills we're going to be finishing up with. The first one, we're going to take, I'm just going to read the numbers again. House Bill 108, House Bill 195, House Bill 307, House Bill 542, and House Bill 625. Those are the bills that we have left in our possession. And so we're going to take up House Bill 108. We have a number of amendments. You should all have received those amendments. Is there just a motion on the underlying bill to begin with?
Motion for ought to pass.
Okay, Senator Gannon moves out to pass. Is there a second?
Second.
Okay, Senator French is second. Okay, what I'm going to try to do, and I've got kind of like a little cheat sheet, if you want to call it that, on how to get through these amendments. The first one that we're going to take up is Amendment 1600. And I'd like to get a motion on 1600.
Motion for ought to pass.
Okay, Senator Gannon moves out to pass. Is there a second? Do you have it, Senator French? Okay, so are you seconding?
Yes.
Okay, this is this is okay, all right, it's, the screen just changed. It kind of threw me for a minute. This had the language from Amendment 114, I think 144, 1114, 1144S. And it includes the the language from House Bill 566, which we were also going to take up, and it has a small amendment that changes immediately to as soon as practicable. So that is the changes with Amendment 1600S. Okay, are there any discussions?
Yeah, sorry, I need a second to look at this one. Sorry.
Yep, no, please take your time. This, I think we just have a few amendments on, and I think people need to make sure they know what they're voting on. Because we're gonna
This
have
takes
a,
the language from House Passed 108 and adds the last sentence, which is the content of House Bill 566, with the small amendment that Senator Carson identified. So it restates, the amendment has a big chunk of bold and italicized language. Most of that language is what was in House Bill 108 that you already voted ought to pass on.
Okay.
is there any further discussion on the amendment? Okay, seeing none, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes. Okay, we have passed Amendment 1600S. The next amendment we're going to take up is Amendment 1251S. This was an amendment that was brought in by Senator Khan and myself. If you want to put that one up so people can see that. Okay. Are there any discussions on this amendment? This is in response to a recent Supreme Court decision, and it just clarifies that records protected under the attorney-client privilege or the attorney work product doctrine, those are protected. Senator Whitley?
Thank you, Madam Chair. I think this is an important enough fix to have some conversation about. And I know folks, maybe folks haven't seen their email this morning, but we did get a letter in support of this amendment from the New Hampshire Bar Association.
Mhm.
And of course, we got a number of letters from different municipalities in support of this fix. And, I think that, I myself have argued that, we need to let the balancing test play out before rushing to create new exemptions under 91A, of course, always erring on the side of transparency. But I think this fix feels urgent given this really bad decision or troubling decision that came out of the Supreme Court. And because this exemption is really already contemplated within 91A, within the plain language of 91A. So this just feels like a fix rather than a dramatic change. It's also, very much settled practice that attorney-client communications and work product just aren't subject to disclosure, even in litigation. And that's why the Hampstead case was really so shocking to so many lawyers. And, I think sort of thinking through that balancing test, I really can't identify a public interest in disclosing this type of information. And I only see a detriment to taxpayers if this type of information was disclosed, because public entities really need to have candid correspondence, select boards, school boards, many of whom are just volunteers. They need to be able to have very candid conversations, correspondence with their counsel to ensure that they're making good decisions, they're operating within the law. And I think exposing these communications under 91A, as this Hampstead case could have led to, would lead to fewer written communications. And I think that would be really detrimental and lead to more costs for taxpayers because of these uninformed decisions. So that's why I feel like this amendment is so important.
Okay. Are there any further comments? Senator Khan?
Yeah, so I think Senator Whitley did a really good job there summarizing why the chair and I would bring this forward. It certainly is responsive to our local governments. And I mean, this is a state that just relies on volunteer effort. And while there's a public right to know, we need to respect that we have the public serving in volunteer positions in government, from planning boards to local governing bodies to the legislature. And, we've got to enable public officials to be able to access professional advice when their decision making is in question. So I feel very strongly that this is an appropriate step that provides assurances to public officials, and it protects the rights that every citizen has to consult an attorney and have that consultation remain confidential until the point that it needs to be disclosed in court or judicial action. So it's just additional justification for at least my vote in support of this.
Okay, thank you. Are there any further comments or questions on Amendment 1251S? Okay, seeing none, I will call the roll. Senator Whitley?
Yes.
Sorry, Senator, we don't actually have a motion
Oh,
on that.
I'm sorry. I thought we did. Is there a
Nope.
motion? I keep forgetting about that.
I'll move that to pass.
Okay, Senator Whitley moves on to pass. Senator French seconds. Okay, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes. Okay, we have one more amendment. You should have all received it. It is amendment number 1687S, and this is a request from Senator Perkins Coca and Senator Daniels. This is dealing with relative to minutes and decisions in non-public sessions and remote access to public meetings under the right to know law. We have seen this before. This was part of an omnibus bill. And basically what it does is it authorizes electronic meetings until, I want to say, between January 1st, 2022 and July 1st, 2022. So I understand that there's no other changes. And it's my understanding that in the House that this provision was killed in an omnibus bill, but it was passed by the Senate. So we've had this request from our colleagues.
I don't know if if the committee would like to hear from Senator Perkins Coca or Senator Daniels again about the importance of this. I don't know if the committee they might be unable to speak to it.
Yeah, I know. I believe Senator Perkins Coca is available, but I mean, this is a request from our colleagues to attach this. And again, we had the testimony. We've discussed this at length. It passed the Senate. So I think it's just a matter of us taking a vote and deciding whether or not we want to attach this. Senator Khan?
Yeah, I'll speak in support of
Okay.
this amendment and offer an ought to pass on Amendment 1687. I guess you should wait for a second before I continue.
And Senator Gannon seconds.
And just to highlight the fact that this is a bipartisan amendment passed the Senate in a bipartisan manner. And this is really an important ability that we need to put into statute for government entities in our state. So I think that this is an appropriate amendment on this bill. And I certainly want to support it. I just want to make sure, and Rick, Attorney Lehman, if you'll opine here, and I know I had some interaction with Senator Perkins Quokka, that in this amendment, there really is a section 1. Or have we lost something in the transitions here?
Section 1 is in House Bill 108 that you've already passed and amended.
Very good.
So this would just be the second section.
The second
Well-
section. Very good.
Nope, okay, no.
Well, the second section was the
It's the previous amendment.
previous amendment. That's the right to know exemption.
Okay,
This amends the bill by replacing all after section 1. So this would overwrite the thing you just did, based not on statute numbers, but based on amendment numbers. But I think that you can vote to, on the fly, renumber the sections of the Perkins Quokka Daniels amendment and agree that section 2 of the amendment will be renumbered section 3.
do you have that, Jenny? Because Jenny will be responsible for getting the amendment, just one amendment, combining all of these. So we just need to make sure that the sections are renumbered
So
when
let
it's done.
me ask this, is it going to be easier for us to rescind our action on the previous amendment and renumber the previous amendment to section 4? Or,
No,
okay,
I don't think so. It's
Because-
just a
because-
question of what has to go through, what happens when you go through OLS. And Jenny knows what to do. So
Okay.
I have confidence in Jenny that she's gonna get it right.
all right. So we'll have sections 3 and 4, and then you'll go back to the effective date in section 4 and adjust those for the effective dates.
I think it's pretty clear that the intent of the committee is to adopt the substantive portions, including the effective dates of each of the 4 pieces that you're voting on that are part of House Bill
Mhm.
108. So I don't think it'll be a problem.
Mhm.
Okay,
Okay, and if I remember correctly, we staggered those dates because it originally, I'm trying to remember, but we wanted to have time for someone to file a bill if they wanted to make this permanent.
The original Perkins Quokka language and the original Daniels language was permanent. There were voices saying that this electronic meeting thing is an experiment that we've been trying out during pandemic, and we should probably you should all get a little distance from it to see how you feel about it before making permanent changes. So the way the bill works is that the becomes effective on January 1, 2022. Then section 3 of this amendment, which is a restatement of the current law, the way it stands today, becomes effective on July 1, 2022. So it's an interesting way of sunsetting the change anticipated in the amendment.
Okay, are there any further questions on Amendment 1687? I believe that's what it is, yes. Okay, we have an ought to pass motion that has been moved and seconded. Okay, I'm sorry, my phone is ringing. We can just hold on for 1 minute.
I was calling you.
Okay,
No,
well, I can't, I don't know, there's a way to disconnect the two and I can't figure it out, so, It's okay. We'll get through it. So we have the ought to pass motion. And is there any further questions or comments? Okay, seeing none, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes. Okay, so the underlying bill has had an ought to pass motion. So we need a bill of, a motion of ought to pass as amended. Senator Gannon moves ought to pass as amended. Is there a second? Seconded by Senator Khan. Is there any discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator French.
Yes.
Okay, I see I mixed it up a little bit there for you.
You did. You are tricky today.
I'm tricky. Senator Khan.
Yes.
Okay, Senator Whitley,
Yes.
Senator Gannon,
Yes.
and Senator Carson, yes. Should we put this one on consent calendar? Or do you folks want to talk about it? I think consent is a good motion.
I
Okay,
think, I move consent,
Okay, Senator French moves consent. Is there a second?
seconded by Khan.
No, we can't do that.
You got me.
Sure.
That's okay, but I just, Madam Chair, just want to make sure before we vote on the consent that, I mean, this will no doubt be a conference committee
Yes.
uh,
Oh, yes, it will.
conversation. Does it behoove us to alert our colleagues to the pieces that are here so that they're aware?
I think that's already happened, quite frankly. So, and I think we're going to see some of this, whether it's done in committee or on the floor of the Senate. So, this will, I'm sure it's, people know that it's here. So is there a second on this?
Yeah, I did.
Oh, okay. Well, I didn't want Senator French to speak for you, Senator Khan.
Good enough. Thank you.
Okay, so is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
Senator Gannon,
Yes.
and Senator Carson. Yes. Okay, who would like to take this one? Just to write the blurb, Senator Khan. And when you do the blurb, you can, well, you can include your, you want to make sure that everybody knows that this is probably going to go to committee conference. Okay, great. Let's go to House Bill 195. We have an amendment on this bill. It is amendment number 1604S. Okay, can I get a motion on House Bill 195? Senator Gannon?
Motion for ought to pass.
Okay, so ought to pass. Is there a second?
Again.
Okay, Senator French seconds. Okay, we have House Bill, we have amendment number 1604S. What this does is just clarifies, it makes it very clear, just exactly what we are talking about. We've added some additional language that says the act of displaying a firearm shall not in and of itself and without additional circumstances. That is the new language. Okay, so that's just a simple change, and again, it's in an attempt to clarify the language of the statute. Okay, is there a motion on the amendment?
Motion ought to pass.
Okay, Senator Gannon moves ought to pass on
Second.
amendment. Let me get that number again. I put it away. Oh, I hate when this happens. I just want to make sure we all are on the same boat. Amendment 1604S. So we have a motion for ought to pass on the amendment. Is there any discussion on the amendment? Okay, Senator Whitley and then Senator Gannon.
Thank you, Madam Chair. So I think that this bill, even with the amendment, I think it does not promote or do anything for public safety. And in fact, I think it erodes public safety. I think this language will have a particularly chilling impact and consequences, as we heard a lot of testimony, for individuals in domestic violence situations.
Mhm.
We heard over and over that firearms are used to intimidate victims, and especially people who are trapped in an abusive relationship, that it is frequently used, just the display of a firearm
Mhm.
as a threatening,
Mhm.
a way to threaten them. I think that adding display of a firearm as an exception can only further empower abusers. Adding it right there in the statute is just yet another tool for abusers and further empowers them for this type of behavior, and gives them basically the ability to legally intimidate their victims. So I think that the display of a firearm, even as amended, sends a very clear message and has the impact of escalating a situation, particularly one involving a domestic abuse situation. So I think that this legislation is not necessary. I think it's a solution in search of a problem that that doesn't exist. I don't understand, really, frankly, how the public good is served by by the passage of this bill. But I do see very much how we can jeopardize the safety and further abuse of victims. So I have a big problem with this, even as amended.
Okay, thank you, Senator Whitley. Senator Gannon?
I appreciate Senator Whitley's protection of domestic assault victims. I think you'd be, if you took a gun out, you'd be establishing, and you were using it as means of intimidation. I think that would be establishing a pattern, and you could go to the judge and say it isn't just merely a display. I think the intent of the bill was for property defense of, if you're showing a weapon in front of your house, like the major case last year that we all saw in every news thing, the people in front of their house, their compound, the gates had been trampled over, and they just wanted to display that they were able to protect their castle, an extension of the castle doctrine. Had they pointed the weapons at people, that would be a different thing than brandishing. They were displaying to protect their property. We believe in the Second Amendment, and I don't think the intent is what I think Senator Whitley, while her points are well taken, I think a good attorney would say this, they're using the gun in a pattern, and the judge could look at that differently than just brandishing in front of your house for protection of your family and property. So I see a difference there.
Okay, are there any further discussions on the amendment? Okay, seeing none, I will call the roll. Senator French?
Yes.
Okay, Senator Khan?
Yes.
Senator Whitley?
No.
Okay, Senator Gannon?
Yes.
And Senator Carson? Yes. So the amendment passes. Is there a motion on the bill as amended?
Move on to pass as amended.
Okay, is there a second? Seconded by Senator Gannon. Is there any further discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator French?
Yes.
Senator Khan?
Yeah.
No? Okay, that's Senator Gannon,
Yes.
Senator Whitley,
No.
and Senator Carson, yes. Okay, 3-2, and Senator Gannon, would you take this one out?
Sure.
Okay. Okay, next we are going to House Bill 307. Is there a motion on House Bill 307?
Motion to
Senator
refer.
Gannon?
Motion to refer.
Okay, motion to re-refer. Is there a second?
Second that.
Okay, seconded by Senator French. I'm going to support the re-refer motion. I think there's a conflict in statute that needs to be resolved here. And that's why I would support that. We need to work on it. We need to clarify this. I do have I forgot what I did with this here. There is a conflict, and the conflict happens in RSA 644:13 in number 2, where they talk about any park, playground, or other outdoor public gathering place designated by the legislative body of the town, of the city or the town. I think that we need to just to look at this very carefully. And we need to find a way to respect an individual's right to arm themselves and still respect the legislative body of any city or town. This just is not ready at this time to move forward. Senator French?
Yeah, I agree. And I'd like to work with Representative Silbert this summer to nail this down to the proper, to cover the proper intent that he brought about when he brought this forward. So this would be a good one to refer, and then we can bring it out this fall or January. Thank you.
Okay. Senator Gannon?
Yep, for me, the bill, the only problem I had, when we had the representative from Portsmouth speak, he talked of gun-free parks, and I asked him, had people ever been raped there, attacked there? And I was afraid at night, someone coming back, like one of my daughters working at waitressing, and if they wanted to possess a weapon, I understand the difference where some people don't want discharge, and I understand where that can be a problem. I can understand there are compact areas where discharge is not allowed, and I can see where there's an overlap and a problem with some of the statutes. And I think if we clarify this, I think we can get a workable bill.
Okay. Are there any further discussions on this bill? On the re-refer motion? Senator Whitley?
Yeah, so I'm unclear whether there could be a workable solution, because I think, we heard a lot of significant testimony that this would really prevent municipalities from the basic right of managing their own property. This is a very important power of our local cities and towns, and we don't want to prevent them from having the ability to manage their own property. And, New Hampshire already has a preemption law. It's existing law. It is what it is. And I think this bill just takes us a step further by intimidating local officials, and, having this sort of overly punitive approach. So it would be difficult to find a solution that would actually work.
Okay, thank you. Senator Gannon?
Just to follow up, we do have preemptions, but there are no teeth. So part of this bill was to give penalties to districts or towns that do not recognize the right of people to have a Second Amendment right, and by flat out saying you can't have a gun here. So I see a big difference between possessing and someone's right to possess. And but where I do see the town interest in a discharge area. So that's what I want to work on.
Okay, are there any further comments on the re-refer motion? Okay, seeing none, I will call the roll. Senator French?
Yes.
Senator Khan?
No.
Okay. Senator Gannon?
Yes.
Senator Whitley?
No.
And Senator Carson, yes. So it passes 3-2. Senator French, would you like to do this one?
That I would. I was going to ask you if I could, so thank you very much.
You're welcome. Okay, next we have 542. And I'm gonna have Rick walk us through this if we can get the amendment up on the screen. And we have, I just want the public to know, we are looking at amendment 1697S.
Okay, this amendment takes the bill back to the original intent when it was introduced at the House, which had to do with protection of religious liberty during periods of emergency. During the House process, there was a section added that broadened it beyond declarations of emergency. And as you recall, during the testimony, there was concerns expressed that there could be a conflict between one person's exercise of religious liberty and another person's right to be go through life without being discriminated against in terms of employment, housing, and public accommodations. There's been a lot of back and forth between various interested parties in this. The Attorney General's office has an interest in continuing to be able to enforce our anti-discrimination statutes. As I understand it, the governor's office has expressed a concern in making sure that protecting religious liberty doesn't work any potential discrimination against people in terms of employment or public accommodations. And so the amendment removes RSA, what would be RSA 456C2 from the bill. It maintains the section concerned, there's definitions, but it maintains the section concerned with state of emergency protection for religious institutions and individuals, with one exception. The House passed bill has 5 paragraphs. The first paragraph creates an absolute protection for religion, which states that no emergency powers can prohibit in-person gatherings under any circumstances. There was concern that that was broad. Fortunately, however, Roman 2 of the House bill, which is Roman 1 in this section of the amendment, states that religious organizations and religious institutions in the practice of religion are treated to the same or greater extent than any other organization or business that's considered essential or vital. There was some pretty compelling testimony by ministers and pastors who felt that they were being treated as non-essential, and also testimony and some intent to make sure that people understand that religious practices for at least some people who engage in it and some people who provide it and run religious institutions as important as any other service that's necessary and vital to the health and welfare of the public. So in trying to work out language that would meet the concerns of all involved here, this was the language that was ultimately agreed upon by that was believed to be able to get 13 votes in the Senate and be enforced by the Attorney General and potentially become law should the governor choose to sign it. So
Okay.
that's how the amendment works.
Senator Whitley?
So, we did hear compelling testimony, and of course the freedom to attend a worship service and practice your religion. It's one of our most fundamental rights, and one that I take seriously also. But I feel like what we're trying to do here feels very, very rushed. And I think there's some legitimate discussion we need to have to balance that most fundamental right with emergency powers, with public health and safety. These are all very real and complex issues that we need to weigh. And I don't feel like we've had the adequate amount of time to do that. So I would hope that the committee would take the course that we did with HB 440 and re-refer this so we can really step back, not be reactionary, but really think how we can best preserve this fundamental right and keep people safe and not rush it. So I would hope that we would be consistent in re-referring this bill, just like we have re-referred 440.
Thank you, Senator. Senator Gannon?
Thank you, Madam Chair. To Senator Whitley, I think as long as it's being looked at when it's examined under a strict scrutiny test, the highest standard that the court has, I think that should alleviate your fears that it's not just going to be a balancing test. It'd have to be no less compelling way to achieve the objective. So I think because it's under strict scrutiny that I can live with this peacefully.
Well, that's actually not my concern, if I may.
Okay.
My concern is balancing this fundamental right with, making sure that our public health officials have adequate flexibility. And so that's the conversation that we need to have. And so I feel like that's the conversation that's sort of rushed. I mean, we did just get this amendment, during our recess. It's an important conversation. It's one that we're going to be having in the context of 440. So let's be consistent in that. That's just all I'm asking.
Okay.
I feel like there's one other thing I should add that is, I think, important in describing the amendment. In the House amended version, it had a waiver of sovereign and qualified and official immunity, government immunities that's withdrawn from here. During conversations with various parties, it was expressed that potentially waiving sovereign immunity or qualified or governmental immunity for some constitutional rights, but not for others, runs the risk of creating a sort of a tiered system of rights where some rights are considered more important than others. And that was something that people felt the need to be careful about, and potentially exposing governments to liability.
Okay, Senator Khan.
Well, I want to thank you for bringing forth the amendment. I think this helps clarify the intent of anybody who wishes to vote in favor of this. I think it was so thank you for clarifying the intent. I will be voting against this, however. I mean, I won't vote against the amendment, but I think the amendment dies if we wind up re-referring this. And I do think this broader discussion of emergency powers is an important conversation to have. And I don't think we've had it. Again, we haven't stepped back from our immediate crisis to analyze what powers are essential for emergency health situations or other emergency situations. And I really would like to analyze this. I know I continued to worship during this emergency crisis. I went and saw my rabbi at times during this pandemic on an individual basis and properly taking precautions. So I know that this is important for us, and I know that religious organizations are organizations that need to, but to need to gather in order to be effective, form effective communities. But we could say that about so many different bodies that rely on the sense of community that's established by their organizations. At which point, I wonder where our emergency powers really will remain. So I think it is important for us to step back, consider the improvements that have been made here, but also think about broadly organizations that need to be exempted, or how slippery that slope is, and how narrowly assembly should be defined during an outbreak of an emergency. So that's what causes me to. So I'll support the amendment, but I will vote against and hope that there's a motion to re-refer, because I do think I think we should have a very comprehensive look, very thoughtful, and not let the emotion of our religious affiliations drive us to pass this abruptly.
Thank you, Senator Khan. Are there any further discussions?
I was going to say,
Senator Whitley?
yeah, I was going to say, I don't think that we have a motion on the floor, so I would put the re-referral motion on the floor.
We're talking about the amendment. Do you wish to re-refer the amendment?
Well, that was my question, Jenny. Do we have I don't know if we started talking about the amendment without an underlying
Right,
motion.
we just started talking about it. So, all right, let's do this. Is there a motion on the amendment? Senator Gannon?
To pass.
Okay, is there a second? Senator French seconds, okay. So, was there, Senator Gannon, you had your hand up. Were there any additional comments that you had?
No.
I
No.
will,
Madam
this,
Chair, do we have a
Yeah.
motion on the initial bill itself?
no, we do not. We just started talking about it. Would you like to make a motion on the initial bill? Senator
Yeah,
French?
I move to re-refer.
So, okay, so I think we gotta pump the brakes for a second here.
Okay.
So technically,
Okay,
we
hold
did,
on.
technically, we did not have a motion on the bill itself, which is something that some committees do, some committees don't do. Some committees just vote on the amendment and then vote on the bill itself. If there is an interest, Senator French, in bringing forward a new motion to do re-refer, you would need yourself and Senator Gannon to withdraw your motions on the amendment first before we can move forward with a new motion.
No, forget it.
Okay, thank you, Jenny. It's been a long day. I'd like to speak to the amendment. I'm sure most of you know that I served on the governor's reopening New Hampshire task force. And one of the entities that we heard from quite a bit were churches. And we heard from many people, and I know that I heard from many constituents of mine who were very concerned about the fact that the churches were closed and they were not allowed to go to worship. Eventually, we found a path, but for many people, Zooming church services did not bring them the comfort that they would usually get when they went to church and talked with their priest and listened to the sermons and that sense of comfort that you get from being in church. This is an important right that we have. And I think initially, in my own opinion, that we had to act very, very quickly when we started shutting things down. And I think this bill creates a path, and I think that that's important, that it says that that this is an essential service, that we need to consider this as an essential service if and when we should ever do this again. I mean, quite frankly, if Home Depot was considered to be an essential service, I think a church and for an individual's ability to go and worship should also be an essential service. I also happen to think schools education in schools are an essential service as well. But it says that it's going to be considered as essential. And I think that that's important, that we recognize that for many people in the state of New Hampshire, the ability to go to church is very, very, very important. For me, the second section says that that they have to comply with neutral health, safety, and occupational requirements, that they just can't open the door and all of a sudden everybody come in. They're going to have to comply. So during COVID, when you had the mask requirement, when you had the 6 feet distancing, social distancing, they would have had to comply with that, provided that the state is not going to enforce any health safety that imposes a substantial burden on that religious service. So I think that what this amendment just actually says is, look, religious services are going to be essential. They're going to be treated as any other entity unless they're and the state can't impose an additional burden on them. That's what this says. And I think that that's okay. It's a beginning. It's a place to start the discussion. And I agree with Senator Khan with the comments that he made, but we have to start the discussion someplace. And we should not abridge an individual's right of worship, of attending a church services, especially during a time of confusion and panic. People were afraid. They turned to the church for consolation and the door was closed. They weren't allowed to meet. They were not allowed to do that. And, I question why that was allowed. And again, I'll just say, hey, if Home Depot could have been open, why couldn't the churches be open? Because I'll guarantee you there were more people standing out in front of Home Depot trying to get in and were willing to wait in line than would be at a church. For many people, churches are essential. And that should have been respected. But, in our haste to do things, it was shut down. So this just protects churches and puts them on footing as everything else. All the more egregious parts of this bill were taken out that I think caused a lot of difficulty for many people who testified. But this just focuses on two things. Number one, churches are essential. They're going to be treated as essential. Secondly, they're going to have to abide by all the same rules and regulations that are being put in place to protect the health and safety and welfare of the people. And the state cannot impose a substantial burden. That's all it does. Senator Khan?
And yet I can't help but feel that the flashpoint for this was probably an event that took place in Jaffrey under a tent and invited people from out of state to gather in our state. And I don't see the kind of guardrails here that, where if New Hampshire stands out as being different and more open and different, suddenly we become the convening space of a large super spreader kind of event. That's a health event. I mean, there might be other kinds of emergencies that need to be accounted for. When we talk about emergency powers and the government's need to exercise special circumstances with emergency powers. So, I think if I have that as one of the instances that caused me to think twice about this bill and this amendment, it is that, and I guess I'll oppose both. Thank you.
Okay, thank you. Are there any further comments on amendment number 1697S? Okay, we have an ought to pass motion. I will call the roll. Senator French,
Yes.
Senator Khan,
No.
okay, Senator Gannon,
Yes.
Senator Whitley,
No.
and Senator Carson, yes. So the amendment passes. Is there a motion on the bill as amended?
Move ought to
Senator-
pass as amended.
Okay, Senator French moves ought to pass as amended. Senator Gannon seconds. Is there any discussion on the bill as amended? Senator Whitley?
Yeah, I mean, I would just reiterate, this is an important conversation. It's certainly worthy of additional conversation. I just don't think it's ready for prime time. And I think we should vote down the ought to pass as amended so we can re-refer it.
Okay, thank you. Are there any further discussion? Okay, seeing none, I will call the roll. Senator French,
Yes.
Senator Khan,
No.
Senator Gannon,
Yes.
okay, Senator Whitley,
No.
and Senator Carson, yes. This is 3-2, and I will take this one to the floor. Okay, next we have, that was 542. Why don't we take up 566? And I'll make the motion to ITL this bill. Can I get a second? Seconded by Senator Gannon. We've already taken the language from this and included it into House Bill 108, and this bill then now is no longer needed. Rick?
Jen pointed out that in slicing and dicing and trying to make 106 work, we left a little dangler here on this bill, which is the provision paragraph M up at the top. I actually don't have it in front of me right now. Section 1 of this bill has a provision in it that has not made its way into 108.
Okay, so I'm looking. Consideration of whether to disclose minutes. Okay, all right, well, I guess I'm going to withdraw my ITL. Will you withdraw yours, Senator Gannon? Okay, so is there a motion on this bill?
Should we amend it with the other bill? Make the
Yes.
changes?
Well, you're on 566. I would suggest the way to do this is to strip out section 2 of this bill and just pass section 1 as a standalone item.
Okay,
Just section
so,
2 of this bill has been moved over to 108.
okay, so I will, we will need a committee amendment, Jen, that will just comprise lines 1 through 5, which is new subparagraph, right to know law, non-public sessions, and section M, consideration of whether to disclose minutes of a non-public session due to a change in circumstances under paragraph 2. However, any vote on whether to disclose minutes shall take place in a public session. That's the language. Okay. So that would be a committee amendment. Is there a motion on the committee amendment?
About to pass.
Ought to pass, and that would include the effective date of January 1st, 2022. So is there a second? Seconded by Senator Gannon. Is there any further discussion on the committee amendment? Okay. Seeing none, I will call the roll. Senator Whitley.
Yes.
Okay, Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes. Okay, is there a motion for the consent calendar? Oh, on the bill as amended.
Ought to pass as amended.
Okay, Senator Gannon moves ought to pass as amended. Is there a second?
Second.
Seconded by Senator French. Is there any discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes.
Move consent.
Okay, Senator French moves consent. Is there a second? Seconded by Senator Khan. Is there any discussion on the consent calendar motion? Okay, seeing none, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes. Senator Gannon, would you like to do this one?
Sure.
Okay. Okay, we have one left, and that is House Bill 625. Let's see. I think what I'm gonna do is just move right to the amendment. And the amendment number is 1672S. And can I get a motion on the amendment? Senator Gannon,
Ought to pass.
is there a
Yes.
second?
Second.
Second by Senator French. Okay, Rick, do you want to walk us through this one too?
Sure. This is actually very close to the House passed version. There are 2 changes. They both occur in the criminal penalties section of the bill. And under the House passed version, anybody who violated any of the provisions of 32944 was guilty of a Class B felony. One of the provisions, Roman 1 of 32944, is the provision that requires any healthcare provider making a performing or inducing an abortion to make a determination of the probable gestational age of the fetus. And that includes taking an ultrasound examination. That requirement under the amended criminal penalties, simply violating that under circumstances where the fetus or the gestational age is less than 24 weeks under the amendment is a misdemeanor. The second change, the violations of the other provisions, in the most relevant one concerning inducing or performing an abortion after 24 weeks remains a Class B felony. The other change has to do with the mental state. The mental state in the House passed bill had the words intentionally or knowingly. Intentionally is not a mental state that is typically part of criminal acts in the criminal code or in New Hampshire law. So this strikes out intentionally and leaves it as knowingly. So a physician would be guilty of a Class B felony for knowingly inducing or performing an abortion after 24 weeks. And there is a slight change in the language of the fine that is in Roman number 2 as well. So it says that the court, it's a Class B felony, and in addition to any other penalties the court may impose, a defendant would be fined not less than $10,000 or more than $100,000. Those are the changes.
Okay, thank you, Rick. Okay, discussion. Senator Whitley?
So, I think that everyone has been struggling with this bill, and I appreciate that. It's a very, very difficult topic, and I know folks feel strongly about it on both sides, and I truly understand that. But what this bill shows me is that, and the amendment, that this national debate and a pretty zealous pursuit to remove access to safe and legal abortion has really seeped into New Hampshire. The fact that we are hearing this in the Senate tells me that that national rhetoric has now made its way to the New Hampshire Senate. And this is despite the fact that the vast majority of Granite Staters believe abortion should be legal in all or most cases. That means the vast majority of your constituents believe that abortion should be legal in all or most cases. And that is polling specific to New Hampshire. I think that this bill, as amended, is extreme. And I think it will really harm our families, those families that are in complex circumstances. And it also extreme because it criminalizes doctors, right? And I think it's particularly extreme and troubling because of its very limited exceptions, including none for the health of the fetus and none for instances of rape or incest. I mean, that takes my breath away. The amendment before us today also retains this incredibly limited exception for medical emergency that absolutely does not do enough to protect even the health of a pregnant person. And I think most troubling, the amendment ignores the tragic stories that we heard during the committee hearing from families and the healthcare community about pregnancies with obvious fatal fetal abnormalities that would result in a fetus surviving only a short time after birth, if at all. So to be very clear, passage of this bill would force someone to carry a pregnancy to term when there is little to no chance of a survival of the fetus. As a mother, I find that notion just cruel and unthinkable. And I just could never support a one size fits all like this bill when we know that every circumstance, every family, and every single pregnancy is unique. And I'm going to give some examples about why. We heard during testimony from a mother who learned at her routine 30-week ultrasound, during which her husband and her toddler were there with her, that there was a fetal anomaly. That 30-week ultrasound was entirely routine because she was advanced maternal age. That's a lovely term that we give to women, over 35. So this was a family, and again, I want to be clear, this is a family that was excited for this ultrasound, and they even had a nursery ready. This, and they wanted to, they wanted this pregnancy. This was a very much wanted pregnancy. But based on what they learned from this ultrasound, they had to make the best decision based on what was best for their family. This amendment would rob them of that ability to make that decision and completely ignores the story. It would leave families like this without access to critical and compassionate care. Because again, every circumstance, every family, and every pregnancy is unique. I also want to share a story about a woman who shared her story with me. And I'm not going to use her real name because she didn't feel comfortable sharing it. So I will call her Sarah, and she is a New Hampshire resident. Now, Sarah never imagined that she would need an abortion later in pregnancy. But she told me her story of her pregnancy about 2 years when she needed an abortion just shy of her 3rd trimester. In 2019, this woman was pregnant with a very much wanted and hoped for baby girl. Then in her 5th month of pregnancy, she was blindsided to learn, again at a routine ultrasound, that her daughter had fetal impairments impacting her brain and spinal cord. Her family had many consultations with some of the best doctors in the world. And as you can imagine, sleepless nights, and through unending tears, they made the heartbreaking decision to end the pregnancy. Once she made this heartbreaking decision, she was fortunate that her OB practice had one doctor willing and able to perform the procedure within the provided timeline. The decision to end her pregnancy was one she ultimately made out of love for her family. And as we discussed, she has experienced, as she shared with me, she has experienced acute grief and loneliness and shame from the politicization of this issue. I just feel like these parents had the bravery to share their stories with us and to be presented a bill that, again, has no exception, no fetal health exception, is just so deeply troubling. This bill imposes arbitrary timelines imposed by legislators, completely ignoring, again, the fact that every family is different, every circumstance is different, and every pregnancy is unique. This bill shames parents like Sarah who have to make these heartbreaking decisions. They deserve our compassion. I also want to remind the committee that wealthy Granite Staters will continue to travel out of state and pay for this much needed abortion access. But women and families that are already on the cusp of poverty, food insecurity, struggle, they will be the ones who will be denied this care. Again, families in these tragic and complex circumstances deserve our compassion and our support, not an arbitrary law that completely ignores the complexity of medical decisions and pregnancies and prenatal care. And to be clear, inserts the government into deeply, deeply personal decisions. The fundamental right to make decisions about our bodies, our lives, and our future is central to the pursuit of racial and economic justice and true gender equality. This bill robs Granite Staters of the freedom to even consult with their own doctor about their own healthcare decisions and to decide the course of their lives. During the hearing, I will stress again, we heard from numerous medical professionals that there is no definite point at which a fetus is viable. Viability is a case-by-case determination and one that must be made by a healthcare provider, not legislators. This bill that puts an arbitrary point in time at which an abortion and medical providers would be criminalized for ending a pregnancy. Criminalized. I think achieving the best possible outcome for a pregnant person in complex pregnancies depends, of course, on the efforts of highly trained physicians, nurses, nurse practitioners. These experts would be severely impacted by this bill because a court would now scrutinize the decisions they must make in a real-time high-stress situation when their only concern should be that of the patient. I think imposing criminal penalties on the medical profession makes this bill beyond extreme. We heard compelling testimony that these overly punitive provisions will have a dramatic impact on the medical profession and on access to quality reproductive health care in New Hampshire. We already have significant issues with attracting providers to our state, and this will only make access to reproductive health care and family planning even worse. Again, to be clear, this bill is an attack on women, reproductive health care, and will end up hurting low-income patients who already experience significant barriers to care. This bill takes us backwards in so many ways, and I truly hope my colleagues will join me in voting in expedient to legislate on this bill. Thank you.
Okay, thank you. Are there any further comments? Any other comments on the amendment? We have an ought to pass motion on amendment 1672S.
Senator, I don't think we actually have a motion yet. Unless
I
missed-
thought we had one before we started the discussion. Yes, we did.
Can you tell me who made the motion?
I believe it was Senator Gannon, seconded by Senator French.
Okay,
I
thank you.
made sure to ask and I wrote it down. I beat you to it, Jenny.
You did. Thank you, Senator.
Okay. Okay, are there any further comments? Senator Khan?
Thank you, Madam Chair. And thank you, Senator Whitley. I think you were extremely eloquent and comprehensive in your reasons for opposing both the amendment and the bill. I join you in that sentiment. I'm very worried about women's reproductive health care in the state of New Hampshire. I think our funding situation on family planning is going to disrupt services for women's reproductive health care. And I think this bill does as well. I believe that we heard the testimony about the state of New Hampshire producing 4 OBGYN graduates per year. And with that slim number and the number of people retiring from the profession in the state, how rural access to reproductive health care is really shrinking in the state of New Hampshire. How many facilities have closed women's reproductive health care services. And we heard testimony from women who have had to wait at every stage along the way of their pregnancy to receive services. And so this line that we're trying to draw, I don't think has a bold line in the sand or in the gestation period. This is both a matter of access, it's a matter of personal choice, and it's a matter of professional judgment. So I side with each of those. I also was very taken on this issue about the fatal fetal abnormalities that women have experienced in the course of their pregnancies, and how we can't put a line to this. I mean, this is where professional judgment and family guidance needs to intersect without asserting, as people said, lawmakers in the examining room. We don't belong there, not on this issue. And indeed, people will be seeking out-of-state services where they can afford it and create income disparities in the access to healthcare. So I believe there's just cause for this to be an inexpedient to legislate motion, and I would hope that we have another vote here in opposition, because I think that's in the best interests of women in the state of New Hampshire. Thank you, Madam Chair.
Thank you very much for your comments, Senator Khan. Are there any comments any further comments? I would just like to say just a couple of things. This is not the nationalization of this issue. I was in the Senate back in 2011, and this issue came up with the idea of 24 weeks, and the bill died because no one could agree about the 24 weeks, what the time period should be. So this has been an ongoing current discussion in our state for quite a while. Secondly, I think that we can all tell stories on both sides of the issue. And I'm not going to belabor the committee today with telling stories from my point of view. We will save those, I think, for the floor. I think that would be the appropriate place for it. And I just want to remind everyone that we probably are going to have a very robust discussion on this with the full Senate on Thursday. So I just want to just remind everyone of that and ask if there are any more comments. Senator French and then Senator Gannon.
Thank you, Madam Chair. I'd just like to say that I personally believe 24 weeks is a modest goal for us to reach on a very divisive issue. And I am very much in support of this bill and will be voting that way.
Thank you, Senator French. Senator Gannon?
Yeah, I'd just like to point out that this has come up in just about every state. 43 of the states presently have late-term abortions at or before 24 weeks. So we will be more going with the vast majority of the country and the way they feel about late-term abortions rather than being. Anyways, enough said.
Senator Khan?
Yeah, and just a question for my colleagues, because, so we had one person testify, this doesn't happen in the state. Nobody's brought forward any case or evidence that this has. And so, unless there is some type of fatal fetal abnormality. So how is this bill treating such a diagnosis if it occurs at the 25th week, if it occurs at the 30th week? I mean, how, because I don't see how this, but maybe you anticipated this question.
Okay.
There-
Senator Khan, I can answer part of your question. The reason we don't know is because we do not collect statistics. So there is no reporting device as to how many people receive an abortion and under what circumstances. We just don't collect those statistics. So I can't supply you with one case. We had one case and it was 2 years ago or something. We just don't collect those statistics. And I think that that is part, something that will warrant future legislation when we're talking about this. I'm not going to answer the second part of the question. I don't feel prepared enough to answer that because I would be speaking from my own personal experience, and I just don't want to do that right now. So, okay. Is there anyone who would like to answer Senator Khan's question? First Senator French and then Senator Gannon.
Well, Senator Khan, as we don't collect statistics, I question where that statistic came from to begin with. I don't know if it's actually accurate.
If I may answer, it came from the president of the state's medical society.
And multiple people testified to that.
But they don't collect statistical evidence, I understand. So how would they know that?
Because they're in
because
the
there
medical
could be a
profession.
source of a complaint or which could come from one of their colleagues, could come from a patient, a family member. There are many sources that could.
So they had one complaint? Is that it?
I don't think that there have been any. I think that's the testimony from the president of the state's medical society.
Senator Gannon, you had your hand up?
Yeah, I thought Senator Khan at the beginning had a question about exact dates on the 24. Did you have a part where you're saying when do they know and how is there leeway? I believe there is a 2-week leeway for the knowing. You didn't ask that?
I didn't, but if you would please explain.
No, I think, well, Rick could probably help me, but I believe it's like knowing it'd be a 2-week period because they can't exactly tell how far you're along. It's somewhat not
Rick?
the science.
In any prosecution, the burden of proof is on the government to convince 12 jurors beyond a reasonable doubt that all the elements of the crime have been met. One of the elements of the crime defined in this bill would be 24 weeks. So the burden being on the government to prove it's actually 24 weeks and not 23 weeks will effectively push if we were able to know with absolute certainty what the underlying facts were, it would be exactly 24 weeks. Since we're not able to do that, the practical effect would be to push it out beyond 24 weeks by some indeterminate amount. It's jurors sitting in a box deciding what the evidence is, but the burden is always on the government to prove all the elements. Is that what you're getting at, Senator?
I thought that's what Senator Khan was asking, but yes, that was what I was getting at.
Senator Whitley?
Yeah, I just also feel compelled to say too, the sort of the idea of collecting data on this, I know has been said a lot of times, but there's frequently hesitancy from this body in collecting data in general as an invasion of privacy. So why do we feel like it's okay to collect data on very intrusive, medical procedures? In this circumstance, we feel very comfortable apparently collecting data. I think that's really problematic. Again, I think, New Hampshire has a long history of respecting people's privacy, and setting an arbitrary date that ignores the realities of when you can get a test, when you can get a second opinion, when you can get an appointment. An arbitrary date, right? That's the problem. And I think, we don't have data, that's correct, but we had strong testimony from a broad spectrum of medical providers sharing with us their expertise because they work in the medical field. Not only do they work in the medical field, but they work in obstetrics. They work in this area. And so they are well aware, of course, of how frequent this is. And so I think, saying that, they're just making this up, I think is very disrespectful to our medical community.
I never said they were making it up. I wondered where they were getting their data from if they don't collect statistics. I don't know how many places in the state abortions are available. Do you?
I don't know.
So
but I trust.
I doubt they all get together at a convention and talk about it and share data. So that was my question, not calling their testimony to be untruthful. It was, I questioned whether it was accurate or not.
Okay, are there any further comments or questions on the amendment 1672S? Okay, we have an ought to pass motion. Are there any further comments? Okay, seeing none, I will call roll. Senator Whitley?
No.
Senator Gannon?
Yes.
Senator Khan?
No.
Okay. Senator French?
Yes.
And Senator Carson? Yes. So the amendment passes 3-2. Is there a motion on the bill as amended?
Ought to pass.
Senator Gannon? Senator
Yes.
Gannon moves ought to pass. Is there a second?
Second.
Seconded by Senator French. Is there any further discussion on the bill as amended? Okay, seeing none, I will call the roll. Senator Whitley?
No.
Okay, Senator Gannon?
Yes.
Senator Khan?
No.
Senator French,
Yes.
and Senator Carson, yes. And I will take this one out, Jenny. Okay, folks, we have finished everything. We're done. What?
No, are we really?
Yes, Jenny, we're done? That was it.
You could move to reconsider something.
Yeah, yeah.
No, I don't think we want to do that. But
Let's try it.
no, no, Senator French. I would like to thank all of you for your hard work. As I said earlier, we were handed quite a few bills in one lump sum, and we held all the public hearings, and we worked on these bills. And so, again, I'd like to thank you for helping me meet this deadline. I couldn't have done it literally without all of you. We may disagree, but we're not disagreeable. And I think that's important as we move forward, because we are going to have our differences. So again, I'd like to thank you all very much for all your hard work. The first
And
year of the
your-
biennium.
And your many weekends working on these. Thank you.
That's okay. That's what I get paid the big bucks for. So can I get a motion to come out of executive session? Senator Gannon makes the motion, seconded by Senator Khan. Is there any discussion on the motion? Okay, seeing none, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson, yes. And Jenny would like to remind all of you, please watch your email. We need to get these blurbs in today so they can get the addendum calendar out. And you don't want to get on Jenny's bad side. I'm just letting you all know. Don't do it. Don't do it. She will hunt you down. So please, yeah, she's going to be calling you. Don't be surprised if you hear a little knock on the door. Well, you get the knock on the door from the Senate president. So Jenny will bring out the big guns for that one. So, please watch your email so we can get these done. I'd like to thank Mr. Lehman, our attorney, for walking us through some of these very complicated issues and complicated amendments. He's put a lot of work into these, and I want to thank him for working with me and bringing the parties together so we can we could vote on these bills today. So is there anything else to come in front of the committee? Okay, seeing none,
Cookies,
I will.
snacks.
You got to talk to Senator Whitley about that. She's the one who has the
I'm on a
chocolate
bad
chip
side
cookie.
right now.
No cookies for you.
No cookies for you.
No
There you
cookies.
go. No
We'll
cookies
talk.
for you.
We'll talk.
Okay.
Well, I think if we can tempt him with cookies, we might be able to keep him here instead of going out for a smoke. So we can help him with his tobacco cessation program. So we can personalize it for you, Senator Fred.
Wonderful. Thank you all very much.
But wait a minute, I need a motion for us to adjourn for the day. Senator Khan moves adjournment. Is there a second? Senator Gannon, is there any discussion? Seeing none, I will call the roll. Senator Whitley,
Yes.
Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson. Yes, many thanks to Jenny, and thank you, Ava, for today. We really appreciate all your help. And Jenny, thank you again for